This lecture is going to cover the legal aspects of EMS. So before we dive in and the legal aspects and how those apply to EMS, let's do some quick review of the legal system within the United States and how we come to have the laws that we're abiding by. So for your branches, there are 3 branches, and that's both at the federal and the state level. We'll start with the legislative branch. This is going to be composed of elected officials, so your Senate, your House of Representatives, both at the state and the federal level. And they are going to be the ones who actually make the laws. So they're going to bring forth a problem, they're going to create a bill, it's going to go through its long process, and eventually it may become a law that we have to abide by. Next is going to be your judicial branch. This is your court systems. They're responsible for interpreting and then enforcing the laws. They're going to resolve disputes based on the interpretation of the laws. So if someone comes forward and says, that's not actually what that says, the Supreme or the state court, depending upon the level, is going to be what actually goes through and interprets it and decides what the goal of that law was to be. What were they trying to do? Common law is defined as a decision that has been made by a judge through a court case based on the interpretation of the various statutes and our constitutions. This can be overturned by another court with higher authority. So the Supreme Court can overturn a state court's decision, but there has to be substantial evidence as to why that lower ruling was no longer correct or no longer viable. Precedents and the law of the state in which providers practice is going to be used to determine what negligence would be and what your standard of care should be. Last branch is the executive branch. Again, this is this is partially an elected position. So think your governor, your deputy governor, your president of the United States. We elect those people, and then the people that we elected are going to appoint people to cabinet positions. And cabinets are going to be the agencies that help carry out various regulations within the governing body. Think OSHA, think the Department of Education, think the Department of Health within the state. One of the big ones that applies to EMS from the federal level is the Department of Transportation. That is what EMS is grouped under, and that's one of our big regulatory bodies. So different types of law, there's civil and criminal. And civil tends to be cases that are brought up and they're disputes between 2 private parties. And this can be done because there's a perceived injury. So malpractice. Malpractice suits would be under civil law. It's not that you necessarily broke a law, but you broke some type of barrier between you and the patient, and there was some type of perceived injury or insult where they were then able to bring that civil suit against you, as opposed to criminal laws. Under criminal laws, you have broken a various law, depending upon what it is, and you're being prosecuted by the government itself, as opposed to a private party. Most of your civil lawsuits that you're going to see are going to be concerned with establishing the liability and who that lies upon. So you are liable for that patient and the care that received. In that civil suit, there's going to be 2 different people that are featured, and one is the plaintiff. That's the person who is launching the request or had the injury. So the patient would be the plaintiff. The defendant would be you. It's the person or the entity with whom the legal action is being brought against. One last definition that we're going to talk about when we talk about civil trials is tort, which tort is referring to the wrongful act that was done that's given rise to the suit. So for malpractice, the tort is the malpractice that brought you here. There's 2 different classifications of the tort. It can be broken down into intentional, which is you intended to cause harm to that patient. So you had malpractice with malice. You are being sued because you used an inappropriately large needle on the patient, which caused them additional injury. Maybe whenever you were cannulating their vein, you actually went too deep, and so you caused nerve damage because you hit a nerve. And in addition to inappropriately doing that procedure, you also chose to start that IV with a 14 gauge needle on a patient who was not profoundly unstable, and really a 20 or an 18. Most of the time 20 would have been a little bit more appropriate. You intentionally chose to use that higher gauge needle, whether for whatever reason you were doing that to the patient. So that's intentional malpractice as opposed to unintentional, which is just negligence. You might not have been doing it with malice. You didn't mean to do it, but you still caused them injury or harm based on your actions. For criminal charges, and again, these are being prosecuted or it's between the defendant, so whoever is being called into court, and the government. So you'll have some type of prosecution that is going to be pushing the case. And it's because you broke some type of law that's been set out. Most criminal charges for EMS can be broken down into one of these 4 areas. So first is assault. An assault is when a person instills the fear of immediate bodily harm or a breach of bodily security in another person, regardless of whether that was actually carried out upon. So threatening somebody, assault. You didn't lay hands on them. You didn't actually physically cause the harm, but the threat was there. You instilled the fear in the person. So that's assault. Whereas battery is whenever you touch someone without their consent. You don't ask your patient for consent to assess them, and you start physically assessing them. And they weren't unresponsive. They were fully alert. They were fully competent to refuse or accept care. And you never gave them that option. You just immediately started touching them. That's technically battery. You touch them without their consent. False imprisonment is exactly what it sounds like. It's when a person is intentionally and unjustifiably detained. The person is telling you they don't want EMS, leave me alone, and they are able to competently make their decisions, and you keep holding them down. That is false imprisonment. And then the 4th one here on the screen, defamation, libel, or slander, are all interrelated. So libel is going to be written defamatory statements. So written statements that are known to not be true. Where we need to be careful about this is in our charting software. I would assume and hope that at some point your instructor has told you in one of these lectures, you will hear that we need to be careful about what we're writing in our narratives, and we never want to make statements that we're not able to fully confirm. None of us are able to do field sobriety tests. So we need to be careful about a patient whenever we suspect that they may have alcohol in their system, that we can't write that the patient was drunk. Even if the patient is telling us that they've had a gross amount of alcohol, we can report that per patient they have had, insert what patient told you, but we can't make those definitive statements. We don't do field sobriety tests. We don't run blood alcohol levels in the field. So we have no way of confirming that. Whenever you write that, that is technically libel. Slander is spoken defamatory statements. So you're intentionally saying something that is not true or you can't possibly confirm. Defamation is kind of the global both of those. So defamation in-house is both spoken and written defamatory statements, so it's libel and slander. So intentionally saying something that could damage someone's good name, hurt their reputation in any way. Ways that you can protect yourself in the field are quite simple. First of all, consent is key. You always need consent. And in another lecture, we'll talk about the different types of consent and how we use them in medicine and in the pre-hospital setting. But if a patient is able to consent, they need to be given that option and they need to consent. And if they don't consent, you don't get to move forward. In all walks of life, consent should be key. So the first way you can protect yourself is to always have consent, especially informed consent, so the patient is fully aware of what and why you're doing it. And then by documenting your actions very clearly. Again, being careful that you don't get into any defamatory statements. But from a legal side, documenting everything acts as your protection if you are ever called into court. There's a saying that you will hear constantly from everybody in EMS whenever you're going through some type of documentation or legal training. And that's that if you didn't write it, it didn't happen. If you're ever called into court for negligent care, some type of criminal charge, something, it really doesn't fly for you to be like, well, I know I would have done this because I always do it. If you didn't write it down, they're going to assume it didn't happen. And that's all it's going to take is one little thing for them to be able to prove that you were maybe not truly honest in your documentation for them to prove that maybe your entire documentation or your entire interaction with that patient did not go the way that you're recounting it. Always document everything. And if you don't want to look at it from the legal side, and I'll talk about this a lot in the documentation lecture, you are a part of the continuum of that patient's care. And the only way that we can appropriately add in or aid in their care is by clearly documenting everything that we see that happens. You, as an EMS provider, are in a very unique position because you're the only person that gets to see that patient at the scene of the incident in their home environment. You have a wealth of information. However, you need to carefully and appropriately document those things without saying statements that could be looked at as untruthful or with intent to sully their good name without justifiable causation behind it where you can prove those statements. So how's the legal process happen now that we know kind of the two different types of legal cases we could see ourselves being pulled in? First of all, a complaint is filed, especially for a civil lawsuit. So the allegations against you and what exactly the patient thinks you've done wrong, and that's going to be filed by way of their lawyer. They're then going to go into a discovery period, and this can last a couple months. It can last a couple years, and this is why they're gathering all of the evidence. Attorneys on both sides. So as soon as that complaint is filed, the attorney of the patient is going to start investigating the crime. They're going to go into that discovery period where they're trying to find everything. They're going to FOIA your report. They're going to ask your service for your standard operating guidelines. They're going to ask the state for what the standard of care should be. They're going to ask nationally what the standard of care should be. They're going to have EMS practitioners and doctors who come in as subject matter experts to talk about what a realistic standard of care is and whether or not you operated within that. Where we get tripped up kind of with this discovery period is because of how long it can take, and why I harped on in the last slide and in the documentation lecture I talk about it, that your narrative is your backing. It's your story. Between when the call happened and when you get called into court, it could be years. You could have had other patients that were exactly like this, and without having a robust narrative that really accurately depicts what happened, you may not actually remember the call that you're being called into court about. So we need to make sure that we're protecting ourselves on the legal side to be ready to defend that care that we gave in the court of law. During or after this discovery period, as they're collecting all their evidence, they'll start filing motions so that they can be seen before the judge. This could be your attorneys seeking to have the lawsuit dismissed, that it's a frivolous claim, that there is no substantial backing to prove of any wrongdoing. The plaintiff's attorney could also file motions to add on additional things to the claim. So if it started out as malpractice, that you did something wrong, and then they find that there are additional torts that could be introduced or included, they can make motions to include those. Either side can use these motions to compel the opposite party to produce documents or additional information. And then lastly is going to be either settlement or trial. So if it wasn't dismissed, you're going to trial. Some attorneys and some clients are able to settle. So both parties meet with an arbitrator or some type of mediation specialist. And outside of court, so not in front of a judge necessarily, they talk about what happened and they find some type of common ground where they can settle the case, whether that's monetarily, that one party goes to some type of counseling, whatever it may be, that they decide this is what we feel comfortable with in not taking this court or this case to court. The other one is you go to trial, and then you'll sit in front of a judge, both sides will be argued, and then decision will be reached. A large part of the legal process is legal accountability, and that kind of starts with the relationship between the provider and your medical director that you have. So every provider, whenever they're actively working, has to have a medical director, and this relationship can be extremely complex. So you're not only answering to your medical director, but these other people. So you have a licensing agency, your credentialing agency. So in South Carolina, you're answering to the Department of Public Health. So the people who actually manage your certification and allow you to practice within the state of South Carolina. You then have your employer who you're also answering to. And most of the time, the three of them don't come into conflict. And I know there's another lecture you guys have already gone through about who exactly tells you and sets up the guidelines and who says what you can do. And it starts with nationally, they've decided this is what's reasonable and can be within the scope of practice for EMTs, AEMTs, or paramedic nationally. The state then gets to a la carte pick from that what they think is appropriate within the state. And that is done by a large number of people to include the state med controls. Then from there, your employer and your medical director get to decide this is what's applicable for our agency. And agencies do not have to meet the full scope of the state, but they also can't exceed the scope of the state. Your medical director really acts as a supervisor for the providers from the medical side. So a lot of you, whenever you hit the field or if you already work in the field, get really comfortable with the idea that you have some type of operational supervisor. Whether you call them a supervisor, a lieutenant, a captain, whatever nomenclature your employer uses, that you have that operational supervisor that you report to that comes and talks to you if you get to work late, if you have some type of write-up or incident on scene. They do your yearly review or yearly, quarterly, however often, reviews with you. But the med control really is one of your supervisors as well. They're supervisor of the medical side. They are the ones who determine what care you're allowed to do and if you're doing that care appropriately. And they tend to work hand in hand with the training department. So the training department of most agencies acts like the arm of the medical director, where they help review the charts and they help make sure that the standard of care that the medical director expects of the agency is being met. Where we run into legal issues is when that standard of care is not met. You are not an agent of the medical director, meaning you're not working on the medical director's behalf. You are still responsible for your own actions. Whenever you start operating outside of what has been determined as appropriate, the next steps are then determined by the medical director, with some input from training and some input from the operations, depending upon where you work. Whether that's remedial training. So you're having a really hard time with IVs, with insertions of biads, with intubation. And so they decide that they're going to come in and they're going to do some type of remedial training. You do an inappropriate treatment on somebody. But if they think it's something that you just need a little bit of extra education on, they can bring you in. And the med control is supposed to have a hand in that med review of your chart and the care and what happened, and then the training thereafter. What is appropriate to get you up to speed? They also can decide to restrict your practice. So there's nothing that says they have to allow you to practice at your certification level within that agency. They can decide either that maybe your knowledge base isn't fully up to that level. So if you're currently credentialed or you're about to be credentialed as a paramedic, they can decide I'm not comfortable with them operating as a paramedic under my supervision, but I'm okay with them operating as an EMT or an AEMT. So they can restrict what you're able to do within the agency. They also can decide that they don't want to supervise you at all. They can fully withdraw your ability to practice within that agency, that they're no longer allowing you to operate within the guidelines that they've set forth. This is often a move not only to protect patients, but to protect the agency. If you've been operating in a way that is seen as negligent enough that your med control is going to restrict or withdraw your ability to practice at that agency, it's because they're worried about not just the patient care that's being given and the effect that it's having on the patients, but the legal ramifications that the agency could be looking at. So our EMS legislation, national and state level, are going to define how EMS is structured, how we allow it to operate within the national scope, but also within the state. So thinking about it on the state level with the Department of Health, they've determined the makeup of an ambulance, that certain types of ambulances have to have at least one credentialed provider, where others may need to have two credentialed providers. One can have like a paramedic and a driver, and the other one has to have at least an EMT on it. They can also give additional scopes or additional skill sets to certain classes or groups of providers. So they can decide that people who are credentialed as flight paramedics and have met the minimum training of that are allowed to do these additional skills. The same with like a tactical paramedic, critical care paramedic, all of the extra designations that you can add on past just the base paramedic. So that's all going to be defined by legislation and regulation within that state level. We also have the same at the national level through the DOT, but those are very broad, and just like guidelines and scopes of practice, the states can then take what the national has said is realistic and they can adapt it to the state that you're living within. They also get to define that, like we talked about earlier, the scope of practice that you're able to work within. Nationally, EMTs are not allowed to place a biad, so some type of supraglottic airway. That's not a national EMT skill. In this state, though, at the moment, they are allowing EMTs to do that, even though nationally, they've said for the scope of practice, it's not available until at least an AEMT cert. That's because within the need of the state for the number of providers we had and the types of patients we were seeing, they decided it was realistic with appropriate training to allow that lower credential to do that procedure. The states get to decide that. They get to decide to tailor the care to what is needed within the states, to the current needs. And that's because the regulations and the legislation within South Carolina might not apply to Montana. We have very different patient densities, very different patient populations, very different working conditions and resource availability. And because of that, Montana and South Carolina cannot have the exact same regulation. It's got to be tailored to the state that you're living within. Some more regulations, these are going to be administrative, and they are also set by the state and the federal. Some examples are, again, those regulations that allow you to do specific skills. So past just your scope of practice, we look at like the medication formulary. Where we can see these shift and we actually watch some of these regulations change was whenever EpiPens became so expensive that most agencies could not begin to afford EpiPens. Previously, our regulation was that EMTs could only administer epinephrine IM via an EpiPen. Well, whenever those became so expensive, is it right for the patient to bear the burden of that? And collectively, the state and the regulatory bodies decided no. So introduce the regulation about the Epi kits, where EMTs were then to be uptrained to drop medications from a vial. You should be learning that within your class, how much to drop and how to appropriately administer it to the patient. So we saw that shift in the regulations and the rules around the practice that you could do and what was allowed and what wasn't. Other regulations administratively that we'll see is licensure and certification and your renewal process. So what exactly does it take for you to get certified, to be able to practice within the state? How do they handle renewal? What does your continuing education look like? In this state, they have decided that as long as you've met National Registry's continuing education requirements and you've kept a good National Registry card, then the state is okay with that. Other states, they have additional continuing education requirements that go beyond national registries. It's what they have decided in their state is important and is useful and they need. On this slide, what I really want to hit, because some of it we've already talked about, is this idea of due process. Whenever you have a complaint lodged against you, whether it's just a complaint within your agency or it's something for a civil and a criminal suit, you have the right to due process. Due process is broken down into two parts. So first of all, notice that you were notified of the complaint, of the issue that's going on. You then need to be given the opportunity to be heard, to voice your opinion, voice what happened. This gives you a fair procedure within whatever process it is, whether it's your internal process for a complaint or something within the judicial system. Some type of hearing would be that heard or that opportunity to be heard. So they bring you in, they allow you to voice your side of what happened. So that way it is not one-sided and skewed by that interaction and what occurred. After that, there's then a final notice of what happened, the findings of the investigation. Part of the investigation, again, is that due process, that you're allowed to know that it was there, that you're not just all of a sudden called in and told, hey, we got this complaint against you, we're going to terminate you, without ever giving you the chance to explain what happened or process through. You should also be given the right to appeal. So if you don't agree with the decision that was made, you don't agree with your termination, you should be given the right to appeal and ask for a different review from a different person. We're going to wrap this up by going through a couple of acts and laws that directly apply to you working in EMS. So first, the Medical Practice Act, and this is going to be what outlines the minimum qualifications for various skills to be performed within a subset of medicine. So this outlines the training, the skill competency, how you review it, and it can be varied by state, but this is what allows you to do the skills, the standard of care that's out there. With the Medical Practice Act for EMS, so let's say you're getting your AEMT, and you, for the Medical Practice Act, and what has been reasonably decided is that you are able to start IVs and you're able to give this list of medications in addition to do this type of advanced airway procedure. So you're able to not only put in NPAs, OPAs, and ventilate, but you're able to place a biad. You then have to go through the education, show competency in it. So go through the testing process to show that you have gotten the education, you're competent in it, you're not going to be a danger to people if you do this procedure. You then have to go into getting your license or certification for it. So just passing the NRE, passing the class and passing the NREMT exam is not enough for you to do those skills in the field. You then also need to get certified with the state to be able to practice. The additional part for EMS with this Medical Practice Act is also saying who can you work with and what are the confines. Just because you have a certification does not mean that you can do those skills. You have to be working in conjunction with a medical director. You have to have that coverage from that medical director saying that you're allowed to operate under their guidance. This means that if you are off duty, you really can't do any of those skills past what a lay person would do for that patient. So you can control hemorrhaging, you can do CPR, you can't start IVs, you can't put in advanced airways when you're not actively on duty and under the coverage of that medical director. And that's all lined out by the Medical Practice Act. This is going to feed in and this is going to be a part of that scope of practice. What can you do and what can't you do? When you operate outside of your scope of practice, and this is very important and I want you to hear me and understand this, operating outside of your scope of practice does not just mean that you're doing something that is above what your certification is allowed to do. It also includes things that your medical director has not allowed you to do. So if you work for an agency that does not do RSI, DSI, DFI, MDI, whatever your service calls medically sedating and restraining a patient and then intubating them. If your service and your medical director has decided you're not allowed to do that and you do it anyways, that is operating outside of your scope of practice. If you start IVs or do procedures when you're not actively working, so you're not covered under that medical control, that is operating outside of your scope of practice. You're doing something that you're not currently covered to do. That is a criminal offense. That is negligence, and that is something that you 100% can have criminal charges against you. You've, at that point, operated without a license because your licensing and certification is only under the medical control you're working for. So if you've done that outside of that scope, you have operated outside of your scope of practice, and thus it's a criminal offense. This applies to you whenever you're a student. So whenever you're a student and you're in this class and you're actively in the student capacity, you are in the classroom, you are on a ride along, you're at a clinical in the hospital, whichever one of those three it may be. You're able to do those skills because you're operating as a student and you're covered under the institution you're going to school for med control. If you are not actively in that student capacity, you're not in a scheduled class, you're not on a scheduled ride along, you're not at a scheduled clinical, and you do those skills, you have operated outside of your scope of practice without a license. That is a criminal charge. Please don't do that. We have two more we're going to talk about. So first is HIPAA. This is an extremely stringent and tight act. And HIPAA is the Health Insurance Portability and Accountability Act. And basically what this boils down to is that somebody has the right to have their protected private medical information not disseminated to people that it does not apply to. This would be criminal and civil penalties potentially if you do distribute it. So this will include any of their personal information, their personal health information. That includes their name, their date of birth, their social, their address, their car, their license plate, anything that can be used to identify that patient would be protected. Past just that identifying markers, their care. So when you're giving turnover in the hospital, we need to be careful. Whenever we're encoding, we need to be careful. Whenever you're coming into class all excited because you had this patient, you need to be careful. You can't come in and go, oh, I went and saw Miss Smith who lives over in Robinwin Place because you would not believe it. She fell and she broke her hip. That is all a HIPAA violation. Somebody's protected health information, any identifying information, or what was going on with them can only be disseminated to people who are directly involved in that patient's care. So if you're turning over to another EMS crew, when you're turning over the patient to a nurse at the hospital, you can talk to them. But even when you go outside and your coworker's like, oh my God, what was happening with that patient? You really can't tell them because that is protected health information. They were not directly involved in that patient's care. They're not able to know. Where we do use some of this information in like training or other instances like that, we make sure to quote unquote like scrub it. So we clean it of anything that could be used to identify that patient. So we may include their age and their sex, but we're not going to include where they were picked up from, what else they look like, any of their name, date of birth, social, anything that could be used to identify that patient is going to be removed. And lastly is going to be EMTALA. This is the Emergency Medical Treatment and Active Labor Act. EMTALA was really important to ensure that everybody got equal and good medical care, regardless of their station, regardless of their race, their sexual orientation, whether or not they had insurance. What we used to run into and what patients used to run into was hospitals trying to shift or not see patients that they thought weren't going to pay their bill, fit into a certain demographic, whatever it may be. Especially the health insurance. So once a hospital would find out that that patient didn't have insurance or was unable to pay, they would not treat them. They would try to divert you to another hospital. They would just kick the patient out. What EMTALA does is says that whenever somebody shows up at a hospital, they have to be assessed for life-threatening emergencies, and those emergencies have to be treated. That you can't have somebody who is brought to you in a near death or in an emergent state. So they have something wrong with them. You can't just immediately kick them out. You have to fully evaluate, and then you have to treat or at least stabilize them. What this means for us, because the hospital will be severely fined. They could lose their CMS, which is the Centers for Medicare and Medicaid Services. They could lose their CMS designation. And as soon as CMS says we're not going to pay that hospital because of these issues, every other major insurance is going to follow suit. Where EMTALA lays with EMS, there's two different sides to it. So for my people who work pre-hospital, who do a lot of 911 transport, once you've made it onto a hospital property, they can't turn you away. If you are on hospital property under EMTALA, they have to evaluate, they have to stabilize that patient. So if you're encoding and you're already sitting on their deck, they can't be like, no, we're not taking this patient. They have to evaluate the patient before they can transfer them somewhere else or divert them somewhere else if you're on hospital property. Prior to that, they can divert you. In order for them to divert you, though, they have to, one, tell you what hospital you're going to, and two, give you the name of the receiving doctor at that facility. They can't just tell you, sorry, we're full. Sorry, we're not taking this type of patient. Sorry, no. They have to say, we're diverting you to X hospital with Dr. Smith as the receiving. For my people who don't do a lot of pre-hospital, maybe do a lot of inter-facility, there's a lot of paperwork that goes into EMTALA for transfers. Your agencies will talk to you about that, but there are multiple forms that the sending hospital, the transferring hospital, has to fill out. They then have to make sure that you as the ambulance crew are fully set up and capable of managing that patient from facility to facility. And then the receiving hospital also has a ton of paperwork that they're responsible for doing. It's not a simple transfer. And again, this is all to make sure that patients are not like economically triaged, that we're not giving a lower level of care purely because somebody maybe doesn't have health insurance or doesn't have good health insurance. And so the hospital is worried about paying for it or not getting reimbursed for it. And honestly, EMS should be in a similar thing. Just because somebody doesn't have insurance doesn't mean we get to not treat them. We still have to treat them and give them the same level of care as everybody else. If you have any questions about this lecture, please notify your instructor.